2024 CR 012097, State vs. Brad Simpson. Would the lawyers please state their names for the record?
Casey Sandoval and Willem Van Zieven for the state.
Stephen Gilmore and Brittany Jones, Mr. Simpson.
Okay, counsel, will you step on this side?
Sure.
And sir, are you Brad Chandler Simpson?
Yes.
Okay. Now, we're back here again because we had a hearing on the motion to quash the indictment last week, the defendant's motion to quash the indictment. But the state wanted an opportunity to file their response, and you did yesterday, I believe.
Can you speak up, Judge?
Friday.
Okay, you filed it on Friday, and then the defense replied to that, correct?
Yes, we filed a short response.
Okay, now let me also get, you now filed another motion for production of grand jury evidence pursuant to Article 20.02. That was filed on the 28th. So on that, we're going to hold off until a later time to see, give the state some chance to, an opportunity to answer.
Of course.
And now with regards to the motion to quash, and we, I think, are on count 1, paragraph B, the act clearly dangerous to human life. Do you have any argument?
Judge, just a brief further argument. I want to refer you to a section in Lugo, which is a case the defense cites, and just point out that Lugo says that A1 and A2 are functionally equivalent, and what they bring up is that a knowing murder under A1 implies a knowing murder under A1 implies an act that is objectively clearly dangerous to human life. So they are functionally equivalent, A1 and A2. So, and defense has conceded that A1 requires no additional notice. So I just want to point out that equivalence between A1 and A2. And then I want to just touch briefly on the Marquez case that I gave you yesterday, which has the exact same indictment language as our case, A1 and A2. And I think the court's analysis in that case implicitly rejects the defendant's argument here. What they do is they go through an analysis of the evidence linking the defendant to his wife's death, and it's remarkably similar evidence to what I expect in this case. And what they say at the end is the jury can infer that act from evidence linking the defendant to his wife's death. So in that situation, what the court's saying is that there can be no evidence of the act itself, and the jury can still infer that and find that A2 murder. So for those reasons, and also for the reasons in the brief, the first and second brief that the state has filed with the court, we're asking the court to deny the motion.
Okay, and counsel?
Judge, just I guess to briefly respond, nowhere in the entire opinion in Marquez do they discuss notice. Only discussing sufficiency of the evidence, what the jury heard at trial. State versus Rosenbaum, out of the Court of Criminal Appeals, says we don't test the sufficiency of an indictment based on the evidence they expect to see at trial. It's tested by the law. And the state invited defense in its latest filing to envision hypothetical situations where an act may not be clearly dangerous to human life, yet still result in death. And the state, of course, is aware of hundreds of vehicle-related cases that they file every single year, where there's an act that may or may not be per se clearly dangerous to human life. Unless they're alleging a firearm or some per se deadly weapon, there are hundreds of acts that could be dangerous to human life or could not be, but still result in death. Lastly, Judge, if the state wants the benefit of presenting this case to a jury on a lower mental state, not intent or knowingly committing a murder, but rather a lesser intent to cause serious bodily injury, it follows that they also assume a greater burden to plead in their indictment, greater specificity, to put me on notice so that I can defend against whether the act occurred or whether the act, if one did occur, had any link in the chain of causation that resulted in someone's death. And I can't do that unless they tell me what it is.
Okay. Anything further?
Nothing further from the state, Judge.
Nothing from defense.
Okay, so with regards to count 1, paragraph B, your motion to quash is denied. Okay. Of course, if the state comes into more information at a later time, then you act appropriately on that, okay? Anything else from either side?
Nothing from the state.
Nothing from defense, Judge.
Okay, that closes the record on this case. Thank you very much.
give them a 30-day status hearing?
Yeah.
Okay.